I love helping clients launch their brand new businesses, right? Whether it's an LLC or a nonprofit, filing the paperwork with the Secretary of State and getting that approval certificate back is a huge milestone. It's the first step towards what will hopefully be a dream and a passion that you're pursuing for the rest of your life. But here's a truth that you have to know. The formation documents, that's just the starting line. It's not the finish line. And while that piece of paper from the Secretary of State gives you somewhat of a protective shield, it only works if you actually maintain it. Too many entrepreneurs make the mistake of filing the paperwork with the Secretary of State and then forgetting all about the legal side of their business until some crisis hits. And the problem is trying to find an attorney in the middle of a crisis is actually really difficult to do. As your business changes, as the laws are changing, the legal structure that you put in place on day one is not necessarily the same legal structure that you need to have in place on day 365. And that is why ongoing legal support is critical. My name is Maritza Shea Nelson, and I help entrepreneurs, innovators, the passion people, the dreamers do what it is that they're passionate about without worrying that all the legal stuff might come back to bite them. Based on the regular legal audits that I perform for clients, in this video series, we're going to take a look at the top areas that businesses often overlook as they get past that formation stage and really start to get up and running and begin to take off. In today's video, we're going to look at the post-formation governance and entity maintenance. Now, I know that's a mouthful, so what am I talking about? I'm talking about all that legal stuff that needs to be reviewed in order to make sure that that foundation remains solid. So the first thing we're going to take a look at today is executing your operating agreement. That is the core shield of your LLC, not necessarily that certificate that you get back from the Secretary of State's office. The operating agreement is the single most important organizational document that you will have in your LLC. That's the piece of paperwork that really solidifies your status as a limited liability company. It proves who actually owns the business. It's one of the first things we're going to look for if your business does get involved in some litigation and the other side is trying to pierce the corporate veil. It is incredibly important and often underestimated, especially by sole proprietors. So when you're the sole member or the sole owner of your LLC, or what we call single member LLCs, oftentimes it's a document that's overlooked. I'll see people grab a generic document from a template or just sign some generic document that they got from, their bank. Lots of problems with those things. And I've even seen business partners who spend a lot of money to get a well-crafted operating agreement put together, but then they make the crucial mistake of not actually signing the thing, and it's not effective until you actually execute it. So, why is the operating agreement so important? Let me start with those single-member LLCs. So while a single-member LLC, right, that LLC that you set up, you're the sole owner of, might not need to define clear roles and responsibilities, right? Because you don't have any business partners, but it's still the critical, tangible proof that you're the one that actually owns the business. It's not the piece of paper that gets filed with the Secretary of State, but that operating agreement that serves as the proof. And it helps to establish that you actually intend to maintain that legal separation between you as a person and that LLC is what we call a separate legal entity or a separate legal person of its own. Anytime I've seen lawsuits or even threats of litigation against small businesses, there's a really common tactic of trying to get past the business and get to the individual owner, because the assumption is that you've taken all the assets out of the business and use them to pay yourself, to fund your lifestyle. And so if we're going to sue your business and try to actually get something out of it, then we need to get past that and get to you and your personal assets. And the way that we do this is by trying to pierce the corporate veil. So what is that? That's a really fancy legal way of saying, hey, you're not running this business like a real business. And so instead of just relying on the business's assets, if we win this lawsuit, we should be allowed to get to your personal assets because, again, you've raided the business for all the cash it's possibly worth. That's the only way this lawsuit would actually make any sense. And in order to do that, what they will do is they will try to show that you're not running it like a real business and you're essentially using that LLC to basically defraud people. So one of the things we'll see asked for is, do you have an operating agreement? Do you have a separate business bank account? Are you doing all of those things that we expect a real legitimate business to do? And if not, that'll be the foundation for the argument to pierce the veil. So without this signed operating agreement, you're at risk of having your LLC just completely dismissed as what we'll call an alter ego of the owner and completely erase that limited liability protection that you thought that you were getting. So the agreement needs to formally define the business's purpose, how it's being managed, and even getting down to the method of dissolution. One of the things that we can do with that operating agreement is make it very clear that in the event that something happens to you, you don't just want the probate court or whoever to step in and dissolve the business. Maybe you want to pass it down to your children, or maybe you had other plans for it so that the business would outlast you personally. Now, when it comes to our multi-member LLC, so your LLC that you have business partners, in addition to maintaining that liability shield, the operating agreement serves as the foundational contract that governs the entire relationship between you, your business partners, and the LLC itself, right? So think of it as your partnership agreement. This agreement, if it's well put together, should help to prevent costly and time-consuming disputes. So when we're working on an operating agreement for multiple members or multiple business partners, we want to cover the ownership percentages. How are profits and losses going to be allocated? How will they ultimately be distributed? Contrary to popular belief, you're not automatically entitled to a share of the profits every week or every month or every year. What an LLC really does is it says, okay, you're entitled to a share of the value if and when this business is dissolved and everything is ultimately distributed. Most business partners, that's not exactly what they have in mind. So we use the operating agreement to sort of update the LLC statute and to figure out, okay, when and how will profits be distributed? We'll also use the operating agreement to set forth the management structure. So whether the LLC is member managed, in which case all the partners are going to have some vote on the decisions, or it'll be manager managed, where you might have a select few partners or an appointed manager who's actually running the day-to-day operations. Now, in Ohio's LLC statute, technically they've done away with that distinction, but oftentimes we'll still include that in an operating agreement just to make it clear who's ultimately responsible for what. The next thing we want to do in an operating agreement is we want to address dispute resolution. Yes, you're going into business with these business partners. Hopefully you know, like, and trust them, right? But what happens if things don't work out? What happens if one of you wants out? What happens if one of you just wants to retire and do something different? What happens if you're no longer getting along? What happens if there's the fight at the family barbecue that then spills into the business? So we'll incorporate this dispute resolution clause or a mechanism, whether it's mediation or going to litigation or maybe arbitration, to try to resolve some of these internal disputes, hopefully before it escalates to the point of litigation. Because if it goes that far, I've seen small businesses spend $60,000, $70,000, $80,000 in attorney's fees fighting over a business in these nasty business divorce cases. The next thing we want to make sure is in the operating agreement, buy-sell provisions. So these are critical clauses that basically predetermine what happens if one of you decides to sell your stake. What happens if one of you is disabled, retires, passes away, gets divorced, whatever. Essentially, it says, hey, if this happens, here's how we're going to determine the value of the business. Then you'll get your share of that and we can go our separate ways and move on. Rather than waiting for this to come up in real time, in which case the person that wants out thinks the business is worth a lot. You might think it's only worth this. And now we're having a lot of fights to try to reach some sort of middle ground in order to work this out so that you can go your separate ways. Essentially, the buy-sell clauses help to ensure a smooth transition of ownership and make sure that outside parties, especially somebody passes away, their heirs, or in the context of divorce, the former spouse, doesn't come in and start interfering with the business and oftentimes trying to raid it for cash when you're trying to use that to continue to grow the business. So the big thing to keep in mind is that every LLC, regardless of its size, no matter how many members or business partners are involved, must ensure that the operating agreement is current, accurate, and actually signed by all of the existing partners. That's the blueprint for your business's legal and operational health. So if you're a single member, I want to know, do you have a signed operating agreement? If you have business partners, has everybody actually signed it, and does it still make sense to you all based on how you're running your business today? Let me know in the comments if any of this was a surprise to you and what other foundational documents you're tackling, especially this month here as we start a new year in 2026. Now, the good news is you don't have to manage this complex legal landscape alone. My clients range from startups to growing businesses and nonprofits across a wide variety of industries. If you love what you do and you want to build something amazing or take amazing to the next level, then let's talk. Schedule a consultation using the links in the description, where you can also download your essential post-formation legal checklist. And stay tuned as we post more videos in this series.